Hi, so today we'll be discussing the admissibility of confessional statements. So, of course, you know that a confessional statement is a statement which is made by a suspect or accused person by which they make an admission of guilt to the commission of an offense. Now, from the Evidence Act, Section 29, you know that for a confessional statement to be admissible at trial, it must be given freely and voluntarily by the suspect. So if there's any coercion or inducement or any sort of pressure applied to obtain that statement, it would render the statement inadmissible. And of course, you should know that it's not just about some negative kind of pressure applied, for instance, to threaten the suspect, but also an inducement. All right. So if you, for instance, promise him something in order to make the statement, and that would also affect the admissibility of the statement. Now, something else that happens sometimes is that the police may trick the suspect into making a statement, where, for instance, a policeman disguises as as a criminal, and so the suspect feels free as speaking and discloses to him that he committed the offense. Would that statement be admissible? The answer is yes, because Section 31 of the Evidence Act tells us that there is no deception practiced by the police that would render the statement as inadmissible, except where it was not voluntarily given. So that is the touchstone that determines admissibility of statements, the voluntariness of the statement. Now, something you find a lot in trial scenarios is that at trial, the suspect would sometimes raise an objection to the admissibility of the statement. Now, in some scenarios, the objection will be raised on the grounds that the statement was not made by the suspect, so the suspect is denying making the statement, while in other scenarios, the suspect will be raising an objection against the admissibility of the statement on the grounds that he did not make it voluntarily, so he was tortured, for instance, to make the statement. Now, how should the court treat these two situations? Now, in the first instance, where the suspect denies making the confessional statement, the court would still admit the statement, all right? But the court will attach little weight to such statement, all right? Which means evidentially it's not going to carry a lot of weight. So the court usually would not convict based on that statement alone, okay? So where it's denied, the court still admits it, but attaches little weight. Now, where the suspect denies the voluntariness of the statement. So where the suspect, for instance, is claiming that he only made the statement because he was tortured, then what the court will do is to hold what we call a trial within a trial in order to determine if that statement was given voluntarily by the suspect or not. Now, a trial within a trial is like a smaller trial within the main trial, where the court would seek to make that determination of whether the statement was voluntary or not. Now, at the trial within a trial, the prosecution would bear the evidential burden of proving that the statement was voluntary. All right, so the prosecution goes first in tendering evidence to try to prove that the statement was voluntary. Now, if the prosecution has suitably discharged that burden, it now shifts to the suspect to try to disprove that statement was not voluntary. Now, of course, if the court makes the finding that the statement was not given voluntarily by the suspect, then it's going to be excluded. It's not going to form evidence for the purpose of that trial. So that is what the court would do when the suspect denied voluntariness of the statement. A trial within a trial would be held by the court, but if the suspect simply denies making the statement, then the way the court would handle the situation is by still admitting the statement, but attaching very little weight to it. So I hope you've learned something else today, and I'll see you some other time. Bye-bye.